Welcome back, everyone. Sheepdog Smokey here, and this one is more and more common, at least discussions about it are, as we move forward. Colorado's new red flag law illustrates the pitfalls of disarming people based on their future behavior. The process for obtaining extreme risk protection orders, ERPOs, that take away people's Second Amendment rights is rigged against the gun owners from the outset. This month, Colorado became the 15th state to enact a red flag law that authorizes court orders forbidding gun possession by people deemed a threat to themselves or others. The new law, which has drawn strong criticism from Second Amendment advocates, including some county sheriffs, illustrates the civil liberties concerns raised by such attempts to identify and disarm people prone to suicide or homicide. Colorado's Deputy Zachary Parrish III Violence Protection Act, which takes effect next year, is named for 29-year-old Douglas County Sheriff's Deputy, a 29-year-old Douglas County Sheriff's Deputy who was killed in 2017 by a 36-year-old veteran with a history of psychological problems. The law allows a long list of people, including law enforcement officers, current or former household members, people related by blood, marriage, or adoption, to seek a temporary ERPO against someone they believe poses a significant risk of causing personal risk. This is a badly written thing. Poses a significant risk of causing personal risk to self or others in the near future. It would be those at significant risk of causing harm to self or others. Need a proofreader. The standard of proof at this stage, when the respondent does not have an opportunity to respond, is a preponderance of evidence, meaning he is more likely than not to pose a significant risk. Depending on what counts as a significant risk, the probability that the subject of a temporary order actually would have used a gun to hurt himself or someone else may be quite low. If 10% is significant, for example, that probability might be around 5%, half of 10%. So if judges are weighing the evidence with such precision, they will be taking away the Second Amendment rights of people who almost certainly would not have committed suicide or murder. In practice, judges will be inclined to err on the side of what they take to be caution. When the only evidence comes from someone who believes the respondent poses a threat, judges will rarely, if ever, decline to issue a temporary ERPO. The possible downside of rejecting a petition, the death of the respondent or someone else, will weigh heavily on the judge's mind, while the temporary deprivation of the subject's constitutional rights will seem trivial by comparison. A temporary ERPO lasts for up to 14 days, at which point the judge has to schedule a hearing where the respondent finally has a chance to challenge the claims against him. The respondent has a right to a court-appointed attorney if he cannot afford legal representation or would rather not pay for it. If he does not show up at the hearing, the court can issue an ERPO without any adversarial process. To obtain an ERPO at this stage, the petitioner must present clear and convincing evidence that the respondent poses a significant risk. Unlike with the temporary ex parte order, that risk need not be in the near future. The judge may consider any relevant evidence, including, but not limited to, recent threats or acts of violence, violations of civil protective orders, violations of previous ERPOs, criminal convictions involving violence or cruelty to animals, unlawful or reckless use of firearms, a history of stalking, drug or alcohol abuse, recent acquisition of a firearm, a job requiring the respondent to carry a firearm, and any available mental health evaluation or chemical dependency evaluation. While some of these factors are clearly relevant, others, such as illegal drug use or the purchase of a firearm, may have little or nothing to do with the question of whether the subject poses a significant threat to himself or others. Furthermore, the judge is authorized to consider literally any other fact or allegation that he deems relevant. If the judge issues an ERPO, it lasts for 364 days, unless the subject seeks early termination and shows by clear and convincing evidence that he does not pose a significant threat. That case will be hard to make, especially since significant risk is undefined, and judges will not want to take the blame should something terrible happen after they terminate an order. The petitioner has a right to seek an extension of the order before it expires, based on the same standard of proof. Eagle County Sheriff James Van Beek argues in a Facebook post that the ERPO process makes gun owners guilty until proven innocent. He notes that when the subject of an ERPO tries to have it terminated, the burden of proof is not on the petitioner, accuser, as in every other legal case, but instead is placed on the respondent, defendant, to prove that the accusations are wrong. He notes that proving one's sanity could be very difficult, as it is highly subjective, nor is proving one's sanity, however that's defined, enough to prevail, since a person may be considered a threat even if he does not qualify for psychiatric diagnosis. Van Beek also worries that if a person is truly in mental crisis, this aggressive approach will create even greater stress, probably resulting in a violent overreaction, as their personal property has been taken without a crime ever having been committed. When police seize guns from the subject of a temporary ERPO, Van Beek notes, it happens with no warning or ability to defend themselves against the charges. Furthermore, he says, the possibility of that outcome may deter troubled people from seeking professional help. The law gives the respondent a civil cause of action against someone who files a false or malicious ERPO, allowing him to recover damages, costs, and attorney fees. But knowing falsehoods or maliciousness will be difficult to prove, and in any case, the more likely scenario is one in which the petitioner sincerely but mistakenly believes the respondent poses a significant risk, whatever that means. With everyone from ex-girlfriends and former roommates to grandparents, in-laws, and second cousins empowered to seek ERPOs, the opportunities for maliciousness or honest error are multiplied. The basic problem, as with other red flag laws, is that the process is rigged against the respondent from the beginning. Once a temporary ex parte ERPO is issued, as it probably will be, there is apt to be a bias in favor of extending it and against terminating it early, since the respondent has already been deemed a threat, even if the standard of proof was initially weak, and the possibly deadly consequences of letting him possess guns will loom large. Given that bias, the indeterminacy of significant risk, and the difficulty of predicting a respondent's behavior, it seems inevitable that the vast majority of people who lose their constitutional rights under this sort of law will pose no real threat to themselves or others. There's a couple of things I want to talk about here. I'll bring that up. One, look up the Maryland red flag law death. A man was shot and killed by police officers serving a red flag warrant. This man had recently won an argument with the person who said he was a risk. But think about the rest of it. Anyone who was a former household member, so that's ex-roommates, ex-girlfriends, could be anyone who claimed they lived with you for any amount of time, for any reason can say you're a threat. You don't get to even speak. You don't even get to go to the hearing where this order is issued, because it happens before you even know it's been done. So all of the evidence is coming from your accuser. When it is a preponderance that's required, meaning more than half, 100% of the evidence presented is against you. No judge is going to say, well, I'm going to assume you have half the evidence, and I just haven't seen the other half yet, so I'm not going to issue. They're all scared of their own shadow, and they're going to issue the order. Then the accuser can literally say, he's only trying to get the order canceled so he can have his gun so he can hurt me. I feel threatened. You can't disprove someone saying they feel threatened. What happens when a girlfriend who was abusive, and let's make it even more common, what happens when a young woman who has been horribly abused by an ex-boyfriend and gets a restraining order against him so he can't legally come anywhere near her, has her guns taken away because he says she said she'd shoot him? Of course, he won't tell her that, or the judge, that she said she'd shoot me if I ever tried to beat the living crap out of her again in violation of my restraining order. And he doesn't even have to do it. He just has to get someone to think she's a threat. Now she's disarmed. Now Psycho Bob can go back over and take out his revenge for her daring to leave him and get a restraining order. This law has already led, or these types of laws, has already led to one death. It will lead to more. Anyone and everyone who is robbed of their property and rights by this will become a victim in one way or another. every single time the agency doing it and the judge by name need to be sued for violation of your Second Amendment rights, for violation of your right to due process, for violation of your right to be protected from unlawful search or seizure. Maybe when a few of them start getting disbarred and removed from the bench for violating the Constitution, the others will realize, well, we already have a law that says if you're abusive, we can take you to court and charge you with assault and battery. We already have a law that says this. We already have a law that says that. But Democrats and liberals don't like this. They want more laws, more laws, more laws that are vague, more and more vague every time, so that ultimately they'll have a law so vaguely written that they'll be able to stand in court and say this law actually means that since he didn't pay for her vacation after they broke up, he owes her that money, and so on and so forth. They're literally moving toward a law that they can twist to mean anything from A to Z and everything in between. And none of them care. Think back to Kamala Harris right before the Jussie Smollett case and her famous anti-lynching campaign. No one ever responded to me, even though I probably tweeted her 40 or 50 times, that murder is already illegal. Why do we need a law saying it's illegal to murder someone when murder is already illegal? Lynching, by definition, is murder. Now, the long and short of it is one of two answers. One, she was introducing this because she may have known what Jussie Smollett was going to do. He's already now officially been kicked off of Empire, and a lot of people are looking at that case. The other is that she truly believes that African Americans have more rights than Caucasian Americans, and they should have more protection under the law. I honestly believe it could be either or both. This is the first step to just give up your guns. Notice that one of the qualifiers for being deemed a significant risk is having a job where you got to carry a gun. How many of these idiot BLM weirdos are going to start saying that, oh, he's a cop, he's a risk, he's a cop, he's a risk, he's a cop, he's a risk? We're going to have police officers disarmed and fired from their jobs because some liberal wacko decides because they're a cop, they're a risk. And you're going to have lives ruined. You're also going to see someone who is likely going through something very tough, disarmed, robbed of their property, and that will cause more problems than it solves. You'll see people stabbed, beaten, run over, and worse. Because rather than following existing laws where you say, oh, wait a minute, they're being charged with domestic violence? Well, while they're being charged and tried, maybe we just keep them in jail. And if they're convicted, they become a prohibited possessor. We can then legally disarm them because they have committed a crime that means they can't have guns. But all of this is irrelevant because liberals don't care about facts. All they want is obedience and power. And they're going to keep pushing until they have laws on the books that literally say, you must obey me. We're headed for 1984, people. The current crop of Democrats read 1984, or the Cliff Notes version more likely, and thought, this is a great idea. We need to do this. And we're powerless at the moment to do anything about it. It's going to be very scary going forward. But honestly, I've talked about this enough. Let me know what you think. As always, remain civil. We do not learn from arguments. We learn from debate. As always, also make sure to like, comment on, and share this video, as well as to subscribe and activate notifications so that you're among the first to know of new content as it is posted. Until next time, everyone have a wonderful day.